Hello and welcome to today's webinar, Export Controls and Sanctions Compliance for Transportation Intermediaries, presented by Jamie Joyner of the Joyner Law Firm. Today's the third webinar in our Risk Management webinar series, and I'm so pleased you've joined us. My name is Teresa Garcia, Vice President of Marketing and Sales Support at Roanoke Insurance Group, and I'll be your moderator. Today's presentation is scheduled to run for 50 minutes with an additional 10 minutes for questions and answers. And please note that all attendees will receive a link to a recording of this webinar and the slides in an email within a few days. We just ask that you complete a brief survey that will launch at the end of the webinar. Oh, having a little difficulty moving the slide. There we go. Also, attendees are eligible to receive 1 CES credit from the NEI for completing the webinar. If you did not include your CES ID with your registration, don't worry, you can still send it in to us via email to infospot@roanokegroup.com. So before we get started, I wanted to take a quick moment to talk to you about how you can interact with us today. We encourage you to submit your questions. So throughout the webinar, type them into the questions box in the control panel at the right of your screen, and Jamie will get to as many questions as time allows at the end of the presentation. So about today's presenter is Jamie Joyner with the Joyner Law Firm. Jamie has extensive experience representing U.S. and foreign companies on a wide range of international trade and compliance requirements related to customs, cross-border trade, and national security. Her areas of practice include export controls, economic sanctions, import and customs law, anti-boycott restrictions, and requirements related to NAFTA and other duty preference programs. She regularly represents companies in administrative proceedings before U.S. government agencies, including U.S. Customs and Border Protection, the Bureau of Industry and Security, and the Office of Foreign Assets Control, and the Foreign Trade Division of the U.S. Census Bureau. Jamie is a friend of mine. We've worked together on the U.S. District Export Council, and I'm so happy that she's with us today. So Jamie, let's get started.
Thank you, Teresa. I'm glad to be here today. We have a lot to cover, so let's jump right in. Here's an agenda of the topics we're going to cover today. I want to first set the stage by reminding us why this topic should matter to all of us, and then discuss how the U.S. government regulates exports and imposes trade sanctions. We'll talk about how you may be able to help your customer know if their shipment is prohibited and not even eligible for a license, even if they apply for one, and how they can determine if they need an export license for their shipment. I'll help you understand what your export controls and sanctions compliance responsibilities are, and give you some real-world examples of how a violation by a customer can become your issue, and more importantly, what you can do about it. Finally, we've seen a lot of changes over the last couple of years to the U.S. sanctions program. From President Obama's announcement in late 2014 about lifting sanctions on Cuba, to the historic agreement reached with Iran last year, and the continuing troubling situation with Russia, I'll break down some of the latest changes for you. Let's start with the why. For national security, foreign policy, and human rights reasons, the U.S. government regulates the export, re-export, and in-country transfer by U.S. and foreign persons of commodities, products or articles, technology, technical data, software, and services to various destinations, end users, and end uses. For the same reasons, under certain sanctions programs involving countries such as North Korea, Iran, and Burma, also known as Myanmar, restrictions are imposed on imports into the U.S. of certain items coming from those countries. There's no better example of why these laws matter and why we should all care and pay attention than the recent cases involving U.S. origin electronic parts being found in unexploded IEDs in Iraq and Afghanistan by U.S. and coalition forces. IEDs, as you may know, are improvised explosive devices that are made by terrorist groups such as ISIS and used against U.S. and coalition forces in places like Iraq and Afghanistan. Some of the unexploded devices that were found, when they were opened up, U.S. parts were found inside. Nobody would want products they sold to end up harming U.S. soldiers. These laws matter, and that is why. They're meant to keep U.S. goods and technology out of the hands of those who would use them against our troops. All right, so how does the government regulate exports of U.S. goods and services? Several different federal agencies play a role. We have the Bureau of Industry and Security, or BIS, within the U.S. Department of Commerce that administers and enforces the Export Administration Regulations, or EAR, which contains a list of items that are controlled for export, known as the Commerce Control List, or CCL for short. Then we have the Office of Foreign Assets Control, or OFAC, within the Treasury Department that has its Foreign Assets Control Regulations. We have the Directorate of Defense Trade Controls, or DDTC for short, within the State Department that has the regulations on military or defense items called the ITAR, or the International Traffic in Arms Regulations. The ITAR contains the U.S. Munitions List, or USML, which lists the attack helicopters, naval aircraft carriers, and other defense articles used by our armed forces and defense contractors. We have U.S. Customs and Border Protection, or CBP for short, within the U.S. Department of Homeland Security, who are the boots on the ground at our airports and seaports, keeping an eye out for both inbound and outbound risks. And finally, we have the Foreign Trade Division of the U.S. Census Bureau within the Department of Commerce that tracks the U.S. trade statistics and through the Foreign Trade Regulations, or FTR, impose electronic export declaration filing requirements. You can access all of these regulations through a single government website, which is ecfr.gov. Both the EAR and the ITAR each control the export, re-export, and in-country transfer by U.S. and foreign persons of certain types of commodities, technology and technical data, software, and services. Now, each term you see here in bold is defined by the EAR, the ITAR, or both. You might know that many of these definitions have very recently been revised in order to make them more harmonized or similar between the EAR and the ITAR. Under the new EAR definition of an export, here is how it's defined. One can mean an actual shipment or transmission out of the U.S., including the sending or taking of an item out of the U.S. in any manner. Or two, transferring by a person in the U.S. of registration, control, or ownership of certain spacecraft. A re-export is now defined as an actual shipment or transmission of an item that's subject to the EAR from one foreign country to another foreign country, including sending or taking of an item to or from such countries in any manner. And then second is transferring by a person outside the U.S. of registration, control, or ownership of certain spacecraft. And finally, an in-country transfer is defined in the EAR as a change in end use or end user of an item within the same foreign country. These new definitions actually just went into effect September 1st. Now, I can't overstate the importance of really truly grasping the meaning of these next three terms: country of ultimate destination, end user, and end use. Many of the enforcement investigations and cases we export controls and sanctions lawyers see involve either one, an intentional effort by someone, often a foreign company, but increasingly from my own perspective by a U.S. company, to conceal the true destination of a shipment or the true end user or recipient. Or number two, a lack of sufficient effort or interest in conducting adequate due diligence to identify the true destination country, the true ultimate end user, and the true intended end use. The new definitions of export and re-export in the EAR make clear that ultimate means ultimate. The regulations now provide the export of an item that will transit through a country or countries to a destination identified in the EAR is deemed to be an export to that destination. In other words, deemed to be an export to that end country. This means that your and your customer's due diligence has to increase. Burying one's head in the sand and saying, "Don't tell me, I don't want to know," just doesn't cut it. Let's talk about what distinguishes the ITAR and the EAR. For years, many of us, and I'm just as guilty as everyone else on this one, have referred to the EAR as the quote-unquote dual-use controls. This is a misnomer, and we simply have to break ourselves of this old habit. The EAR have always controlled some purely military items, but now, after several years of items transitioning from the ITAR to the EAR under the Obama administration's Export Control Reform Initiative, there are now lots of purely military articles that are regulated under the EAR. So it makes it a little more difficult to distinguish between the ITAR and the EAR, but we need to avoid making this incorrect statement that the EAR are purely commercial or dual-use controls. The ITAR, for the most part, regulates items that are truly military in nature, like fighter jets, Navy aircraft carriers, and ballistic missiles. The EAR regulates commercial and military articles, software, technology, and certain activities that relate to those items. Let me make a quick but important comment about imports of sensitive items coming into the U.S. In contrast to the EAR, which does not regulate imports, the ITAR regulates the temporary importation into the U.S. of defense articles. Permanent imports, on the other hand, are regulated by the Bureau of Alcohol, Tobacco, Firearms, and Explosives, a law enforcement agency that is part of the U.S. Department of Justice. So I've mentioned this Export Control Reform Initiative, but what is it? Well, back in 2010, then Secretary of Defense Bob Gates announced the administration's plans to build, quote, higher fences around a smaller yard, meaning around our most sensitive and critical technologies. A report published by a working group that he headed up when he was the president of Texas A&M University had found that restrictions on exporting were actually putting U.S. companies at a disadvantage to their European and other foreign competitors. They even identified instances of the foreign competition advertising their goods as ITAR-free. They found that this ultimately leads to a threat to our national security, because if our companies lose those large bids, they lose profits and funds for more R&D, and we could lose our edge on technology in the global marketplace. The plan for accomplishing the reform goal was articulated as the a single export control list, a single licensing agency, a single enforcement coordination agency, and a single IT system. As it became clear that congressional approval was going to be needed to accomplish some of these, the mandate given by the White House to BIS and DDTC were to get closer to a single export control list and to transfer less sensitive items from the USML to the CCL, or in other words, from the ITAR to the EAR. A massive effort has taken place over the last several years, and what many scoffed at and thought could never be done has been largely accomplished. Of a total of 21 categories on the U.S. munitions list, review has now been completed with final changes published on 17 of them. This involved both DDTC and BIS and numerous DoD and other stakeholders reviewing each category of the USML to determine which items no longer warrant control under the ITAR and transitioning those items to the Commerce Control List on the EAR. The result is that many items previously controlled by the Department of State under the ITAR are now controlled by the Department of Commerce under the EAR. It is important to understand that the transitioned items still, for the most part, require an export license from BIS unless a license exception applies. It's not that moving them off the USML means they're no longer controlled. A lot of export control compliance personnel who work for defense contractors and other companies that used to be regulated only by the ITAR had to enter and learn the brave new world of the EAR and how things work over at BIS. There are a lot of estimates out there about how much ECR has cost industry, but regardless of how you feel about whether it's been worth it and whether it was ultimately a good thing or not, one thing is clear, and that is it was a major accomplishment of what seemed at the outset to be a Herculean task. Now let's talk about OFAC. They administer and enforce economic and trade sanctions based on U.S. foreign policy and national security goals against targeted foreign countries and regimes, terrorists, international narcotics traffickers, and those engaged in activities related to the proliferation of weapons of mass destruction and other threats to the national security, foreign policy, or economy of the United States. OFAC implements the sanctions through its Foreign Assets Control Regulations, or FACR, some of which are country-specific, such as the Iranian Transactions and Sanctions Regulations, or ITSR for short. the Cuban assets control regulations, and the Ukraine-related sanctions regulations, which were implemented in response to the actions and policies of Russia, including Putin's purported annexation of the Crimea region of Ukraine. It's important to be aware that because sanctions are often imposed in response to threats and world events that may be rapidly developing, the restrictions might not be found in actual regulations. They might, for quite some time, exist only in presidential executive orders. Also know that OFAC issues numerous general licenses, which are exemptions that are published on their website and that anyone can use so long as all the requirements are met. These are often not part of the regulations, but like the executive orders, they are binding and available for use once they're published. So you need to bookmark and be familiar with the OFAC website if you're involved in any way with international shipping or international sales. Under the various OFAC sanctions programs, exports to certain countries are prohibited unless a general or specific license from OFAC or BIS is in place. Just a few examples of export transactions that are prohibited unless an export license is in place include: 1, virtually all exports to Iran with certain exceptions such as certain food and agricultural products and medical devices. 2, virtually all exports to Syria with a few exceptions. 3, exports to Cuba, although several new license exceptions, general licenses, and exemptions have been implemented starting in 2015. 4, exports to Sudan with just a few exceptions, and 5, exports to North Korea also with just a few exceptions. Under some of the OFAC sanctions programs, imports into the U.S. from certain countries are prohibited unless a general or specific license is in place. Here are a few examples of imports that would require a license from OFAC. Virtually all imports from Iran, with a few exceptions, such as certain household and personal effects, low-value gifts, and certain foodstuffs such as pistachios and caviar, and Iranian origin carpet. Virtually all imports from North Korea are prohibited, again with certain limited exceptions. Virtually all imports from Sudan with limited exceptions. Imports of Burmese origin jadeite and rubies, or articles that are made from those types of stones. Imports of Syrian origin petroleum or petroleum products. Imports of Cuban origin items unless covered by an exception or a general or specific license from OFAC. So let's say you're at a dinner party this weekend, and after learning what you do for a living, someone asks, hey, the wife and I are going to Cancun next month, so can I bring back some Cuban cigars this time? Do you know the answer? Well, I'll help you out. The answer is your new buddy can buy them and smoke as many as he wants down in Mexico. Just don't try and bring them back. That's still illegal even after the changes that came out in March of this year.
So there'll be some disappointed cigar smokers.
That's right. That's right. Last, let's talk about services and facilitation. Under some of the OFAC sanctions programs, U.S. persons are prohibited from providing assistance, including providing or arranging for others to provide transportation-related services. A U.S. transportation intermediary would be in violation of OFAC regulations if, for example, they provided services that relate directly or indirectly to shipments to Cuba, Iran, Sudan, Syria, or North Korea, unless the general or specific OFAC license covers those services. Now, let's talk about your customer's transactions. There are some transactions that are just very unlikely to be approved, even if your customer applies for a license. These are said to be subject to a, quote, policy of denial. So sometimes it's not even worth the effort it takes to apply for a license. They should just let it go. Examples of these include, first, applications to DDTC for a license to export defense articles to a proscribed country such as China or Venezuela. This is because China and Venezuela are two countries that are subject to a U.S. arms embargo. Second, applications to BIS to export oil field equipment to Syria. It's just not going to happen. And third, applications to OFAC to export pressurized valves from the U.S. to Iran. Depending on who the end user is, what the intended use is, and other facts, this one may stand a better chance of approval than the other two, but still relatively unlikely. There are many other transactions, though, that just require a license first from BIS, OFAC, or DDTC. and subject to first receiving the approved license and complying with all of its terms, conditions, and provisos, as well as applicable regulations, the export may legally be sent. For a U.S. freight forwarder or other transportation intermediary to provide service in connection with a physical export, in other words, a shipment of any tangible items, such as products or commodities of any kind, software on a disk, technology consisting of printed papers or design specifications being shipped physically out of the U.S. to a foreign country, the forwarder should first verify, number one, that no export license is required from any U.S. government agency, including BIS, DDTC, or OFAC, and that this is an informed and reliable determination that your customer has made. Or two, you should be verifying that an export license from the appropriate U.S. government agency is in place, that the license number has been recorded on the export and shipping documents, and that that license number has been reported in the AES filing for the shipment, and that you've preferably that you have received and maintained in your files a copy of the license. Now, that's not a requirement, and you may want to just record the license number, but I do always recommend that you at least have that license number, if not an actual copy. But how, you may ask, do you verify number one, item number one, verifying that no license is required when you are not the shipper? By understanding the requirements and questioning your customer on them. This may be tough medicine, but it's good customer service in the end. They may not act too appreciative, but you're doing them a service by educating them on the requirements and possibly saving them hundreds of thousands of dollars in penalties or worse. So let's talk about what those requirements are so you can push back a bit on your customers to do their due diligence. There are 4 key facts or pieces of information you need about any export transaction in order to determine if an export license is required. These are often referred to as the 4 W's. The first W is what is it? This means how is the item classified? What is its export classification, meaning its USML category or its ECCN, Export Control Classification Number. This does not mean the HTS or Schedule B code. Ask your customer, have they determined if the item is included on the CCL found in the EAR or the U.S. munitions list found in the ITAR? If they're just counting on you to call it EAR 99 and move on, that's a huge red flag. Next, where is it going? This means the country of ultimate destination, not an intermediate destination or transshipment country. Does your customer understand the meaning of ultimate destination country? A large percentage of the criminal prosecutions and civil enforcement cases, and we'll see some of those here in a minute, involve transshipment through a non-prohibited country such as Germany, the UK, China, or the UAE, where the U.S. exporter knows the shipment will be shipped on to a sanctioned country such as Iran. You can be liable if you ignore red flags and proceed with knowledge that items you forward or transport are in fact intended for a sanctioned country. Third, who will receive the item? This means who is the end user, not an intermediate consignee. You need to conduct denied party screening on all known parties to the transaction, including end users, intermediate consignees, foreign transportation and logistics service providers. Does your customer understand the meaning of end user? You can be liable if you ignore red flags and proceed with knowledge that items you forward or transport are in fact intended for a prohibited end user. Finally, what will they do with the items being shipped to them? This is referred to as the end use. Does your customer understand the meaning of end use? You should tell your customer they are responsible for confirming that the item will not be used for a prohibited end use, such as nuclear, chemical, or biological weapons. The last 2 pieces of information, end user and end use, are referred to as the catch-all controls because they apply to a wide variety of items, including items classified as EAR 99. The most important practical tip I can give you today is to make your customer aware they should request signed ultimate destination, end use, and end user statements. If you remember nothing else from this webinar, please remember this. Your customer should automatically and regularly be getting signed ultimate destination, end use, and end user statements from their customers. According to BIS, forwarding agents have compliance responsibilities under the Export Administration Regulations, the EAR, even when their actions are dependent upon information, or instructions given by those who use their services. This comes from the BIS guidance for freight forwarders found on the BIS website. BIS goes on to say, agents are responsible for the representations they make in filing export data. No person, including an agent, may proceed with any transaction knowing that a violation of the EAR has, is about to, or is intended to occur. It is the agent's responsibility to understand its obligations. Again, those are BIS's words. Now, let's talk about one of my favorite topics and probably one of the least understood topics in the area of export controls, routed exports. I've done enough work with freight forwarders and customs brokers throughout my career to understand the business reality that many of you probably depend on routed exports. In fact, for some of you, your only source of business may be the jobs you get from your agents overseas. I get it. But understand the risks and know what it is you're taking on when you handle U.S. routed exports. There are specific responsibilities and liabilities you are taking on when you agree to do business in this way. In a routed export transaction in which the foreign principal party in interest, or more realistically, their local agent or broker, engages you, a U.S. agent, to handle the export out of the U.S., you become the exporter under the EAR for export compliance purposes. This means that you are the one responsible for determining if an export license is required, and you are the one responsible for applying to BIS for that export license. Do you really want to do that? Would you be willing to be the actual applicant on an export license for your customer? What if they don't comply with the terms and conditions imposed by BIS? It's your license. I'd call that your problem. Just because the U.S. seller is being listed as the U.S. PPI in the AES filing, make no mistake that under the EAR, if it's a routed export, you've just signed up to be the exporter. As BIS says in its published guidance, forwarders, especially those acting as the exporter in routed export transactions, should understand the Know Your Customer guidance and red flags found in the EAR. Agents and exporters should determine if red flags are present, exercise due diligence in inquiring about them, and ensure that suspicious circumstances are not ignored. Failure to do so could constitute a violation of the EAR. Both the agent and the principal party in interest who has authorized the agent are responsible for the correctness of each entry made on an AES submission. Good faith reliance on information obtained from the PPI, the principal party in interest, can help protect an agent, but the careless use of NLR, no license required, or unsupported entries can get an agent into trouble. Agents without the appropriate technical expertise should avoid making commodity classifications and should obtain support documentation for ECCNs. Forwarders may be subject to criminal prosecution and/or administrative penalties for violations of the EAR. BIS has not hesitated to hold forwarders liable for participating in illegal transactions. Even in non-routed transactions, you shouldn't let your guard down. This is because the EAR in section 758.3 provides that, quote, all parties that participate in transactions subject to the EAR must comply with the EAR. Therefore, some compliance responsibility also rests with the freight forwarder. BIS advises that all parties dealing with export transactions, including forwarders, maintain a vigorous and effective export compliance program. So here's an interesting case from July of this year. A freight forwarder in Jamaica, New York, and its owner and president agreed to pay $500,000 with $350,000 conditionally suspended to settle charges that they violated the EAR by concealing and misrepresenting the identity of the exporter or U.S. principal party in interest on the electronic export declaration and submitting false statements to BIS in the course of an investigation. Now, what I want to talk about now is how this can become your issue, because in that previous case, there was obviously some intentional actions to evade the requirements going on by the freight forwarder. I would imagine most of you who've gone to the trouble to dial in this call are not predisposed to do something like that. So more practically for you, the real risk is that others who would do something illegal would seek out your services and essentially get you to help them unbeknownst to you with something that is illegal. So let's take a look at some of these other enforcement cases, because it's important to have your eyes open and know that there are bad actors out there and they may seek out your services. Our first case takes us to Milwaukee, Wisconsin, where a Wisconsin man was sentenced in October of last year in connection with the purchase and export of luxury vehicles to China. He pleaded guilty to conspiracy to engage in wire fraud, conspiracy to engage in identity theft, and conspiracy to misuse of the AES system to further his criminal activity. I want to point out that the U.S. government charged him criminally with misuse of the AES system. Remember that you are responsible for the representations you make in the AES system, and that these constitute representations to the U.S. government, and the government takes false representations very seriously. Our next case takes us to Brooklyn, New York, where the CEO of an international metallurgical company pleaded guilty this June to conspiring to export a metallic powder to Iran that can be used to coat gas turbine components such as turbine blades, and that can also be used in aerospace, missile production, and nuclear applications. I want to highlight here that the CEO attempted to hide the true destination of the goods by making arrangements to first ship the goods to Turkey. The important takeaway here is that freight forwarders and other export service providers need to be aware that there are people out there who will misuse your services to skirt the laws. Asking for country of ultimate destination information from your customers and not self-blinding to red flags is critical to helping prevent you from inadvertently becoming involved in violations of U.S. law. In another case in Boston, Massachusetts, a Chinese national was sentenced in January to 9 years in federal prison for supplying U.S. origin pressure transducers that could be used by Iran to make nuclear weapons-grade uranium to an Iranian end user that's identified on the SDN list. The parts were apparently exported to China first using a fraudulently obtained export license and then shipped on to Iran. While this defendant's actions occurred before the recent changes to the U.S. sanctions on Iran, it is important to note that these acts would still violate U.S. law if they occurred today. Okay, now let's take a look at another case out of New York. Here, a Chinese national was arrested in April of this year after traveling to the U.S. to meet with what turned out to be undercover agents in connection with his attempt to obtain U.S. origin high-grade carbon fiber for export to China. The carbon fiber is primarily used in aerospace and military applications. To avoid detection by law enforcement, the individual allegedly directed the undercover agents to use unmarked boxes and falsify shipping documents regarding the contents of the boxes. Obviously, if you see any indication that the shipper wants you to use misleading tactics or put incorrect information on shipping documents, this is a major red flag and you should run, not walk. Lastly, a California computer software company and its UK subsidiary agreed last year to pay $1.5 million to settle charges that the companies violated the EAR when they shipped U.S. origin equipment and software from the U.S. and the UK to Iran, Syria, and Sudan. According to BIS, some of the company's violations were done with knowledge. The takeaway from all of this is to keep your eyes open. Don't be naive about the fact that there are some bad actors out there, and they're not just overseas. Make sure that you and your colleagues have a healthy skepticism and push back on your clients when they tell you they don't know who the end user is or where the products they're asking you to ship will end up. Be alert to and investigate red flags when they come up. Your customer may complain now, but they will thank you later. Let's turn now to our sanctions updates, starting with Crimea. OFAC imposes broad sanctions on the Crimea region of Ukraine. The exportation to or importation from the Crimea region of Ukraine of goods, services, and technology is generally prohibited. In addition, new investment in Crimea by U.S. persons is also banned. BIS imposes a license requirement on virtually all items, including EAR 99 items, to be exported, re-exported, or transferred within the Crimea region of Ukraine. Now turning to the sanctions on Russia. In response to the annexation of the Crimea region of Ukraine by Russia in 2014, the Obama administration imposed export restrictions and sanctions targeted at Russia's energy and defense sectors. In August of 2014, BIS implemented restrictions on exports of certain items destined for Russian deepwater, Arctic offshore, or shale energy exploration or production. Then, in September 2014, BIS expanded its existing military end-use and end-user controls to impose a license requirement on various items that may not otherwise require a license if the exporter has knowledge that the items may be used by military end users or for military end uses in Russia. In December 2014, BIS again expanded its controls on Russia, this time related to certain microprocessors for military end uses and end users in Russia and certain other countries as well. There's been a great deal of confusion on the scope and application of BIS's Russian industry sector sanctions in particular. So let's talk about those now. These sanctions prohibit the export, re-export, or in-country transfer of certain types of items when you know that the item will be used directly or indirectly in exploration for or production of oil and gas in either Russian deep water, and that means greater than 500 feet of water, 2 Arctic offshore locations in Russia, or 3 shale formations in Russia, or when you are unable to determine whether the item will be used in such projects. Now, the key to understanding these sanctions is to understand that it is a 1+1 restriction. What this means is you can either have a 1+1A and there's a BIS license required, or you can have a 1+1B and there's a BIS license required. The number 1 in our formula is what we just discussed, that the item is destined for one of the 3 oil and gas related end uses we just identified, or that you're unable to rule that out. You're unable to determine that they won't be used in those types of projects. If the answer to that is yes, that does not necessarily mean a license is required. It depends whether you also have either 1A or 1B present. 1A relates to the export classification of the items being sent. Is the item classified in one of the 8 new ECCNs, or is it classified in one of the 53 Schedule B codes BIS has listed in these sanctions? If yes, then a license is required. If the answer is no, then go on to 1B, which relates to who the end user is. If the end user of the items is one of the 5 major Russian oil and gas companies, Gazprom, Gazprom-Neft, Lukoil, Rosneft, or Surgutneft-Gas, or one of several other oil and gas companies in Russia that BIS has added to its entity list over the last 2 years, then a license is required. Part of the confusion about these sanctions stems from the fact that we were all used to the entity list companies being totally off limits. In other words, for most entities included on the entity list prior to these Russia industry sanctions, generally those entities were prohibited from receiving any U.S. goods, including EAR 99 goods. And it's important to understand that there are many Russian entities on the entity list now for which the restrictions are this broad. In other words, they can't receive even EAR 99 items. However, Gazprom, Lukoil, Rosneft, and the other oil and gas companies in Russia that have been added under these sanctions are not subject to a flat-out blanket restriction. You have to actually look at the license requirement column in the entity list to know which restrictions apply to each specific entity that's listed. Now let's look at the military controls BIS added for Russia in 2014. A license from BIS is required for the export, re-export, and transfer in country of items subject to the EAR and contained on a list found in Part 744, Supplement Number 2 of the EAR, if the exporter, re-exporter, or transferor has knowledge or has been informed by BIS that the item is intended for a military end use or military end user in Russia. BIS also expanded its controls on certain microprocessors for military end uses and end users in Russia. Now let's talk about the changes that have occurred to the Iran sanctions. As widely covered on the news, on July 14, 2015, the P5+1, which is China, France, Germany, Russia, the UK, and the US, the EU and Iran reached a joint comprehensive plan of action, known as the JCPOA, to ensure that Iran's nuclear program will be exclusively peaceful. January 16th of this year marked implementation day of the JCPOA. The changes, for the most part, do not affect U.S. companies. The U.S. has committed to license 3 categories of activities that would otherwise be prohibited under the Iranian Transactions and Sanctions regulations, subject to certain limitations. They issued a statement of licensing policy for activities related to a re-export to Iran of commercial passenger aircraft and related parts and services. They issued a general license known as General License H, authorizing U.S.-owned or controlled foreign entities to engage in certain activities involving Iran that was previously prohibited and known as the secondary sanctions. And third, they issued a general license authorizing the importation into the U.S. of certain Iranian origin carpets and foodstuffs, including pistachios and caviar. This is my second key takeaway from this presentation that I hope you remember, if nothing else. The primary sanctions on Iran, those that prohibit U.S. companies and individuals from engaging in transactions involving Iran, remain in place. Nothing has changed for most U.S. companies. That is, unless you're planning to open a caviar and champagne bar.
But with no cigars.
So what does this mean for you? U.S. freight forwarders remain prohibited from the following activities without authorization from OFAC and BIS, where applicable. Forwarding or otherwise assisting with shipments from the U.S. that are destined for Iran, regardless of the immediate or intermediate destination country. Providing logistics or other services or otherwise assisting or facilitating a foreign-to-foreign shipment destined for Iran, even if no U.S. origin items are involved. And providing services to or engaging the services of any Iranian carrier, bank, agent, or other Iranian person or entity. Remember to screen all parties to every transaction against OFAC's SDN list or any other applicable U.S. denied persons list, and remember that certain vessels are included on the SDN list. Finally, let's talk Cuba. In December 2014, President Obama announced a historic shift in U.S.-Cuba policy in an effort to begin normalizing U.S.-Cuba relations. However, the United States continues to maintain a comprehensive embargo on trade with Cuba. OFAC and BIS have amended their regulations to implement changes in U.S.-Cuba policy. BIS has created what it calls License Exception SCP, which stands for Support for the Cuban People. It authorizes the export and re-export of certain items to Cuba that are intended to support the Cuban people by improving their living conditions, supporting independent economic activity, strengthening civil society, and improving the free flow of information. In January and March 2016, OFAC further amended the Cuban Assets Control Regulations, or CACR, to continue implementation of the new U.S.-Cuba policy. These amendments relax sanctions related to a number of areas, including travel, financial transactions, telecommunications, and import activities. BIS published a Cuba-related rule expanding license exception availability for vessels transporting cargo and further easing restrictions on certain exports of items to Cuba. Also, as of March, persons subject to U.S. jurisdiction may purchase or acquire Cuban origin merchandise, including alcohol and tobacco products, while in a third country, provided those products are consumed while in a third country. Remember our dinner party conversation with your new friend who wants to bring home some Cubans from his trip to Cancun? This is why he can't bring them back. But as of March, he's free to buy and consume as many as he wants while in Mexico. This authorization just doesn't allow for the importation of any Cuban origin merchandise into the U.S., including as accompanied baggage. So we've covered a lot of ground. Let's summarize. U.S. freight forwarders have to comply with U.S. export controls and U.S. sanctions, including restrictions on exports, re-exports, in-country transfers, imports, and facilitation, which can mean providing services or assistance. U.S. freight forwarders have responsibility and liability in connection with the transactions they handle. This comes straight from the EAR. Routed export transactions carry special risks and concerns for U.S. freight forwarders because the forwarder becomes the exporter for EAR purposes and must comply with export licensing requirements. Precautionary compliance steps, including the implementation of an export and sanctions compliance program, should be taken to help prevent violations by your customer and therefore involve you in a violation, and to mitigate your own risk of exposure in connection with transactions you handle. With some planning and some careful due diligence, you can make compliance a value add for your customers, which will let them know you have their back and are raising questions they need to consider to protect themselves. You will also be protecting yourself in the process. Let's open it up for questions.
All right. Thank you, Jamie, for a very informative presentation. A lot of information to get to in a short period of time. Right now, wanted to remind you again that you will receive a recording of today's webinar, and the slides will be delivered via email within a couple of days. Now, if you do have any questions, it's a good time to enter them into the questions box in your GoToWebinar viewer. So we do have a couple of questions, Jamie. One is, we require SLIs to be signed and sent to use as the forwarder prior to our submission of the EEI to AES in a routed transaction. Am I hearing correct? In a routed transaction, am I hearing correct that we are still ultimately viewed as the exporter of record, and could we be held liable for the commodities we have never seen or touched?
Scary but true. The EAR makes it clear that in a routed export, the freight forwarder, and this is assuming that we have a true and correctly structured routed export transaction, but if that is the case, all the required written authorizations are in place and all of the requirements to truly make it a routed export are in place, the U.S. forwarder becomes the exporter for purposes of the EAR. And that is the person who's responsible for determining licensing requirements. And to determine if you have a license requirement, you'd have to classify. And you can't realistically classify without product specifications and other information. It is, you know, as I was mentioning during the presentation, I recognize the business reality that some forwarders would only do routed exports, or it just wouldn't be something they could kind of eliminate from their business. What I would recommend is that you have a very robust export compliance program in place, and just take as many steps as you can to obtain the information that's needed in writing from your customer and from the USPPI. But it is a fact that that you are the exporter under the EAR. And the reason for that, by the way, is that the exporter has to be in the U.S. Like to apply for a license, the regulations, if you go to the section on the export licensing requirements, it says the applicant must be in the U.S., meaning physically present in the U.S. So I'd encourage you to take a look at that. And also the guidance that I was referring to that's available for freight forwarders on the website is quite helpful. If you haven't seen that before, I'd recommend taking a look at it or rereading it. It was quite helpful.
And what website was that?
The BIS website, so bis.doc.gov.
Okay.
Freight forwarder, guidance for freight forwarders from BIS.
Okay. So we have another question here, and I hope I'm reading this correctly. When an item is used indirectly, how far attenuated does the use have to be before the rule no longer applies?
Not 100% sure what the question is getting at. I would imagine it's a question about a prohibited end use, and perhaps how connected to the prohibited end use, like use in a chemical weapons plant, for instance, does it have to be? Boy, I would just, really caution that if there are any indications about a downstream use of a product in one of those prohibited end uses, that's a pretty major red flag. I would want to do some further investigation on that, some further investigation of where it's going to be used and why. But I would say it doesn't, any indications that the item is going to end up in that use. Now, maybe you might be talking about the foreign incorporation concept, where parts and components might be leaving the U.S. and going to a foreign country, say France, and then they're incorporated into an end item that then may be sent on to a prohibited end use. I would just be very careful and take a look at Part 744 of the EAR on prohibited end uses, because that's pretty serious. There's not a whole lot of reported cases that are based purely on the restriction of prohibited end use, but I think that's one you don't want to get too close on the line on for sure. Too close to the line on for sure.
Okay. We have another one here. Is it possible to be the FPPI's filing agent without being the exporter and making license determinations?
That is a good question. So there is what I call an alternate routed export, and that term is not used in the regulations or really anywhere else. I use it to distinguish a regular routed export where the forwarder is making the filing. What the regulations address is where the U.S. PPI, the U.S. seller, in other words, wants their terms of sale to essentially be a routed export. So let's say an export shipment. They want it to be a routed export, but they want to actually control the filing of the EEI to make sure that it's done appropriately, which is something that I think is, in many instances, a good idea. It's kind of the best of both worlds for a U.S. shipper, but for the forwarder, I can't think of any way you kind of get out of being considered the exporter. The EAR just doesn't really contemplate that, I don't believe. It talks about if you have a routed export, that the U.S. agent for the foreign principal party and interest is the exporter. And again, that's because that FPPI, who is, they are, by the way, they have to, for it to be a valid routed export under the EAR, your customer, and it's typically done through their agent who's then subcontracting you, has to agree that they are responsible for determining the license requirement. But they're a foreign party, obviously, and they're not physically present in the U.S. And so the EAR wants someone in the U.S. to be identified as the exporter, essentially what we've all traditionally called the exporter of record. The EAR doesn't use that term anymore, but they say the exporter for EAR purposes. So I'm going to keep thinking on that one, but I cannot right now come up with any way you can sort of contract around that or structure it in such a way to get you off the hook.
Okay. So again, Jamie, you mentioned a couple of takeaways and then the BIS website. Were there any other just quick follow-up tips that you'd like to leave with the audience today?
I would just reiterate again the importance of your customers obtaining the signed ultimate destination, end user, and end use statements. And by the way, those don't have to take any particular name or form. You hear them referred to as lots of different things. It's called an end user certifications or end user statements. But the purpose behind them is to have the foreign recipient certify in writing that whatever the country they specified is the country of ultimate destination, whoever the end user is. And it also will go on to say things like they understand that diversion contrary to U.S. law is prohibited. So that is, I would say, you know, it's not a legal requirement except for as a supporting document in certain types of license applications, but it has become such an expectation and really one of the most practical ways to help do your due diligence and to document your compliance that I would say it's a best practice that is almost becoming a norm. And so I would just, again, you know, highly encourage that. And as a forwarder, I would ask for a copy of them to keep in my file, because that would just be the best evidence of due diligence to have available, is that those signed end user ultimate destination and end use statements.
Yeah. And one of the audience members today also suggested that reminding folks to use ACE to get their export report.
Yes.
To ensure their agents are filing information correctly.
Absolutely. Such a wonderful tool now, and there was a backlog for quite a while on getting the new accounts, but that seems to be moving more quickly now. So I would highly recommend that you recommend that to your exporter clients if they're not already, if they don't already have an ACE account and are getting their ACE data.
Great. Well, thank you for that comment too. So Jamie covered a lot today. We really appreciate that. Such a complex topic to get in such a short period of time. And again, we wanted to thank everyone for joining us, and thanks Jamie for participating today. And I'd like to remind you too, we have another webinar coming up on November 1st. It's the last webinar of the year in our series. It's Best Practices in Carrier Selection. It's presented by Sam Tucker of Carrier Risk Solutions. You can go to our website for more information about that and additional upcoming webinars and industry updates. Thank you again, everyone, and this concludes today's webinar.